Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Hello everyone, my name is Safira Anissa and I'm student of International Program for Islamic Economics and Finance, batch 2019. So today I would like to present about istinbat method and case. In preliminary, we know that there are 4 types of source in getting the Islamic law. So the first is Al-Quran. Al-Quran is a source of Islamic teachings that serve as a guide in managing life in this world and hereafter. And the second is Sunnah. Sunnah is an explanation of what has been written in the Quran, that it can be understood that Sunnah in the form of words, deeds, and takrir of the Prophet Muhammad SAW. And the third is ijma. Ijma is done by the scholars. It needed as a parameter in testing the truth of the result of ijtihad. So when with the consideration that ijma is taken collectively, is much stronger than that made by individually. And the last is istinbat, because nowadays many problems arise. So there is such legal istinbat methods that the object of discussion is the usul fiqh. So the istinbat is finally each imam perform his own legal istinbat. So those various methods of legal istinbat were born. It's like qiyas, istihsan, istislah, uruf, istishab, and so on. And mujtahid imams such as Abu Hanifah, Imam Malik, Imam Shafi'i, and Imam Ahmad bin Hanbal each have their own methods of ijtihad. So now we are getting into the istihsan discussion. According to Imam Shafi'i's point of view, he has rejected the use of istihsan as a source of law because he is considered a mujtahid to have taken something that he thinks is good and not based on arguments obtained directly according to the text or nash of the Quran and Sunnah. Further, Imam Shafi'i said that using istihsan as a legal istinbat is just witless and looking for the pleasure only. And for other reason, istihsan has relevance to the renewal of Islamic law. Its relevance lies in maqasid syariah, because the renewal of Islamic law aims to realize and maintain the benefit of mankind as much as possible, which is maqasid syariah. While istihsan is one of the legal istinbat methods that prioritize maqasid syariah and always tries to realize and maintain the maqasid syariah well. So in Arabic term, istihsan is defined with the meaning consider something good or follow something good. So according to Al-Ghazali in his book Al-Mustashfa, just 137, that istihsan is all things that are considered good by mujtahid according to their minds. Because istihsan come from istihsana yastahsin. So istihsan among scholars are defined in different terms. The first is removing the law of a problem from the law of similar matters to another law because it is based on something else that is stronger in the view of the mujtahid. It's according to their mind. So the second is the evidence that exists in the mujtahid but cannot be expressed in words. And third, leaving what is the consequence of certain qiyas for a qiyas that is stronger than it. And the fourth, the practice that's the strongest of the two propositions. So there are 6 types of istihsan. The first istihsan bi anas, the second istihsan bi ijma, the third istihsan bi al-urf, the fourth istihsan bi ad-darurah, the fifth istihsan bi al-qiyas al-khafi, and the sixth istihsan bi al-maslahah. So here is the istihsan bi anas, or istihsan based on a first or hadith. So there is a first or hadith about the law of a case that is different from the provision of general rules. The example is mu'amalah transaction is by asalam. By a salam contract in which the goods that yet exist. However, because there are texts from the hadith of the Prophet that allow it, so the sale and purchase of greeting is legal. So the second is istihsan bi ijma. Istihsan bi ijma means the transfer of law from general provision to other provision in the form of exception, because there are ijma provision that exclude. So for example, ordering goods such as cupboards, because by the convention the goods must be available, but scholars agree that it is permissible to maintain the needs of the community and to avoid difficulties that may occur when the transaction is prohibited. So the third is istihsan bi al-urf, or istihsan based on custom. So it is a legal exception from general rules based on good habits. The example is muamalah, is that buying and selling mu'attah is prohibited because in qiyas, this buying and selling does not have consent. However, because it has become a habit in society, it is law. So the next is istihsan bi ad-darurah. Istihsan based on an emergency, ad-darurah. So the action that are prohibited because of an emergency becomes allowed. The example is being allowed to use and participate as a member of BPJS for emergency reasons or for the health reasons. So the next is istihsan bi al-qiyas al-khafi, that istihsan based on hidden qiyas. So the case of agricultural land wakaf, according to the provision of Qiyas Jali or the real Qiyas, this wakaf is the same as a sell and purchase contract because the landowner has terminated his property rights by transferring the land. Therefore, the rights of others to pass through the land or the right of others to drain water to the agricultural land through the land are not included in the wakaf contract unless it is stated in the contract. And the next is istihsan bi al-maslahah or istihsan based on benefit. So the example is come from mudarabah and musyarakah contracts. The application of revenue sharing on profit distribution as well as the application of collateral in financing in the Islamic banks, one of which is the application of collateral interest contracts such as mudarabah and also musyarakah contract. By default, there is no need for collateral for this contract, but for the sake of benefit, it is permissible for Islamic banks to apply collateral in mudarabah or musyarakah contracts. So the conclusion is, in the development of Islamic law, istihsan is very necessary. Therefore, the Islamic economic scholars are part of the mujtahid scholar, as the economists must ijtihad to solve various economic problem. In this case, the Islamic economic scholars are required to answer the following question. Maybe the question whether or not various modern business transactions are permissible, the harm of certain form of business is lawful, and providing solution for economic. So thinking about relevant contract for Sharia financial transaction and so on. So because so many problems arise nowadays, and the Al-Quran just provide the general rules, so the economist has to solve the problem based on the legal istimbat. So maybe that's all from me. Thanks for your kind attention. Wassalamualaikum warahmatullahi wabarakatuh.